Now I see Ms. Harris. Okay, welcome. Okay, Ms. Tatman, you're up.
May it please the court. My name is Kaylee Tatman and I'm representing the state of Florida. I would like to reserve 5 minutes for rebuttal, please.
Sure.
The post-conviction court erred in granting the second successive motion for post-conviction relief because the defendant simply did not meet his burden at the evidentiary hearing, and the order was not based on substantial competent evidence. Of course, at a post-conviction evidentiary hearing, it's the defendant's burden to present evidence to substantiate the allegations in his motion. And at this evidentiary hearing, the only evidence presented was that of Judge Jacobus, who testified that there was a plea offer conveyed in front of him on the first day of trial that was rejected by trial counsel without consulting his client, Mr. Downs. However, and this plea was for an unspecified non-sex misdemeanor with 1 year of probation and a withhold. However, Judge Jacobus also testified that he was unaware of the hallway plea, which had been properly conveyed and rejected in the hallway outside of the courtroom the same day. And that plea was for battery, a non-sex offense, 1 year of probation, and no sexual offender designation. And therefore, Judge Jacobus's testimony did not prove or provide evidence that the plea conveyed in front of him was a different plea than the one that had already been conveyed and rejected by Mr. Downs in the hallway outside of the classroom or courtroom. So trial counsel could not be ineffective for failing to convey a non-different plea than the same one that had already been rejected. And therefore, the trial court erred in granting that motion. Additionally, because there was no evidence that it was a different plea, the defendant failed to substantiate his claims of newly discovered evidence because he was aware of this plea that had been conveyed and rejected by him since 2001 of the date of his trial. As well as the fact that this hallway plea has been the subject of litigation from the first motion for post-conviction relief. It's already been litigated, and therefore the second or successive motion should have been dismissed as procedurally barred, as there was no evidence provided to prove that it was a new plea that the defendant was unaware of. And if there are no questions at this time, I will actually reserve the remainder of my time for rebuttal.
Okay, well, I want to warn you, I'm not going to let you, come back and argue for 15 minutes on rebuttal, but we'll
That's fine.
Okay.
Thank you.
All right. Okay, Ms. Harris.
Good morning. My name is Elizabeth Harris, and I'm here on behalf of Mr. Downs. The state has argued that Judge Jacobus' testimony did not support a finding or did not prove a second finding. The point I believe that the state overlooks is that, in fact, Judge Crawford, who heard the evidence, made a distinct finding that there was, in fact, two pleas. In his order, he finds that the Judge Jacobus, number one, he finds Judge Jacobus credible. Secondly, he finds, it's in paragraph K, I believe. Well, I might be wrong on that. Oh, I'm sorry, it's paragraph E of the final judgment or the order on the post-conviction. He finds that the plea that Judge Jacobus spoke to was the second plea. And he makes a very distinct finding that the first offer was for 18 months probation for an ag assault. The state fails to address that finding by the trial court in any fashion. Does not allege that the finding that the court made that the first offer was 18 months was not supported by competent substantial evidence. And I would suggest to you that in fact it is. When we look at the And I think it's important to note that the state asked that the court take judicial notice of the proceedings in this case. And this case has a long history. It's been before the appellate courts a number of times. Defense counsel has been found by the 5th District Court of Appeal to have been deficient in his performance. There were difficulties in finding the prejudice prong because of the lapse of time. Judge Cohen wrote a fairly detailed opinion on that. indicating that the passage of time was the problem here, but that there were in fact some difficulties with the evidence as it was presented, and that the defense counsel was in fact deficient for not having contacted witnesses. So that's the context that this case comes again before this court to address the conduct of trial counsel. So in the course of making or asking the trial court to take judicial notice, in that they point directly to a couple of things that are very, very important. Number one, the state points to the affidavit of the public defender. And in that affidavit, the public defender that represented Mr. Downs on direct appeal, the affidavit in if necessary, I have some page citations to give you, but I know the court has reviewed the record in detail. But be that as it may, the public defender says that there was a plea of 18 months for aggravated assault. And with that testimony corresponds precisely with the testimony that the assistant state attorney gave. Because when you look at what the assistant state attorney testified to in 2016, she says a couple of important things. First, she says, I don't remember a plea. Second, I only offered misdemeanors once or twice. That's in direct conflict with Judge Jacobus, and Judge Jacobus is found to be credible. Judge Jacobus says this was a misdemeanor plea. She says she recalls very clearly a conversation with the second assistant state attorney, and they discussed this, what she called a legal fiction for ag assault on these type of L&L crimes. In her cross-examination, she says very clearly, I cannot say with 100% certainty that it was or was not offered, the ag assault or ag battery. So we have evidence that Judge Crawford was able to examine and draw the conclusions, the factual conclusions that he did. And so there's competent substantial evidence for which this court can give deference to those findings that in fact the first offer was for 18 months on an ag assault. With that in place, we now have Judge Jacobus who comes in and says, I heard another offer offered by the state for a misdemeanor withhold. And he's very clear, it was never conveyed. And he says what the second part that's very, very important in Judge Jacobus' testimony is he says, and off we went. That from that, Judge Crawford, the trial judge, could draw the inference that they proceeded directly to trial.
What is to counter the theory that it was either the same offer or that it was conveyed at some point? I mean, but mainly the state's thrust and is that it was the same offer.
Well, but I think we have evidence before Judge Crawford that in fact that there are two offers, and he makes that conclusion. One was for an ag assault, one was for a misdemeanor. That's two offers. And he makes that finding, and there's competent substantial evidence in the record for the court to have made those two findings.
And if I recall, and correct me if I'm wrong, that at sentencing, trial counsel said something, I'm quoting it here from the brief. The state had offered probation withhold, which he turned down. That told me he wouldn't take a misdemeanor because he wasn't guilty of anything.
And I think that is very important because from that statement, it is reasonable for Judge Crawford to infer that there was another offer that defense counsel said he's not going to take a misdemeanor. That supports Judge Jacobus's testimony that in fact a misdemeanor was at some point offered and he turned it down, meaning the defense attorney.
Defense counsel turned it down.
Yes. I think that statement certainly allows Judge Crawford to make the inference from the evidence that in fact there was a misdemeanor that defense counsel took, heard, and didn't convey. And so there's enough in this record to support the judge's finding that there are two offers. And with that in place, we cannot be talking about a successive motion, particularly if you look at what was raised the first time. The first time was that I was not properly informed of the consequences of the plea. I turned it down without my lawyer properly informing me. There's actually a second plea that I didn't know about. And Judge Jacobus came, and it's important to remember, Judge Jacobus says a couple of things. This really stuck out in his mind. So something is awry here. He remembers this nearly 20 years later, 15 years later. It sticks out in his mind that he says, this was not conveyed to this defendant. In the point that this is a misdemeanor, in light of the judge's finding that the second or the first offer was an ag assault, that makes this two pleas. And Judge Crawford, this court, treats that with the deference that the law provides, and that the state's not come forward and demonstrated that there was a lack of competent substantial evidence for Judge Crawford to make that factual conclusion. And I think I've covered the points that I thought I needed to cover. If the court has any additional questions for me, I would be very happy to answer them.
Okay, thank you, Ms. Harris. Ms. Tatman?
Thank you, Your Honor. Just a few quick points. In regards to the two pleas, the first being ag assault, that comes from the affidavit of Allison Havens, which was attached to the petition requesting to file the first motion for post-conviction relief, wherein she says that the defendant told me, so she doesn't have personal knowledge, but that the defendant told me that there had been a plea for ag assault of 18 months. However, in the 2016 evidentiary hearing on the first motion for post-conviction relief regarding being improperly advised about a plea, the defendant testified that it was a 12-month plea specifically to battery, not 18 months, not ag assault. He said it was a 12-month plea, and that has always what the hallway plea has always been. And so based on the defendant's own testimony of the 12-month battery versus Jacobus's credible testimony regarding the 12-month non-sex misdemeanor, there's no evidence provided that those were in fact different pleas, especially given that they were conveyed on the same day.
But remind me, Ms. Tatman, wasn't there also a difference between the two offers? Depending on which facts you believe, there are maybe a couple of differences. One was the ag assault versus battery, but another one was a withhold versus no mention of withhold.
Yes.
Is that true?
Yes, it is. The defendant in the 2016 hearing did not mention anything about a withhold. However, in the order denying that motion, the court did note that it appears that some sort of plea offer involving 1-year probation and a withhold was most likely made. Additionally,
but we know that the plea that Judge Jacobus described included a withhold, correct?
Correct, it did. I will also note that looking at Mr. Senior's testimony from the first 2016 evidentiary hearing, when talking, he was actually asked about conveying pleas. And he said that whenever he is given a plea offer from the state, he always told his client about it. And when asked whether it was his normal practice to convey a plea offer, he responded, "I always do, always did, and always will."
But I've never actually seen testimony from a defense attorney who said, well, sometimes I didn't.
That's true. However,
and Judge Jacobus testified that he didn't in this case.
Absolutely. However, if it was in fact the same plea that had been conveyed in the hallway and had already been rejected moments before, the defense counsel obviously cannot be ineffective for failing to convey the same plea that, again, had just been rejected. I would also note that going back to Mr. Senior's statements at the sentencing hearing about he turned it down, The he in that statement is clearly referring to Mr. Downs, not Mr. Senior himself. Otherwise, he would have said, I turned it down. And so I think it really just comes down to the fact that there just wasn't enough evidence presented at this evidentiary hearing for the post-conviction judge to make the findings that he did. And because it was the defendant's burden at the hearing to substantiate his allegations, and he simply was unable to prove that this non-specific non-sex misdemeanor was different than the, non-sex battery that had already been conveyed and rejected on the same day.
Well, can you just, so walk me through, you said it's non-specific, I mean, repeat what you said, and then please and rebut again the assertion of defense counsel that one of them was an ag assault and one of them was a battery.
Okay. In the Allison Havens affidavit that was attached to the petition requesting to file the first motion for post-conviction relief, she has one statement that says, defendant told me that there had been a plea offer for 18 months ag assault. That was never brought up at any other proceeding. At the 2016 evidentiary hearing on the first motion for post-conviction relief, the defendant himself testified that the plea offer in the hallway that he was misadvised on was for 12 months battery with no sexual offender designation.
So in that proceeding, which was not about the ineffectiveness was not for failure to convey a plea, but was for misadvice regarding whether to take a plea. The defendant himself testified as to what the plea was that he was advised to reject.
Correct.
And that was different than an affidavit than an affidavit filed with this petition.
Correct.
So there was a discrepancy there. So the live testimony was that it was a battery.
Yes.
And the state's position is that there's no difference between ostensible difference between that battery and the one that Judge Jacobus recalls having been offered in open court and not disclosed to the defendant.
I mean, to the extent that there was a plea offer conveyed in front of Judge Jacobus, he testified that it was specifically a non-sex misdemeanor. And he also testified that the prosecutor never actually said what it was. We don't know what it was. It could have been a battery.
But what do we have?
But he did say
misdemeanor, which is not different than what you're saying, which was in open court at a hearing in 2016, a battery.
Right.
But he did say, Judge Jacobus did say that it included an offer of a withhold adjudication. And that there was no mention of that with regard to the Hall offer, correct?
Not through the defendant's testimony, correct.
Or through anyone's testimony, correct?
Correct, yes. I would note though that with the plea offer being conveyed in front of Judge Jacobus as being so non-specific that obviously, yes, there was a plea offer conveyed, but with no specific details, it's unclear. I mean, it could have been any kind of misdemeanor. There's no way to tell what it actually could have been. If it was, say, a battery, then that is the same thing that had just been conveyed and rejected by the defendant.
Let me ask you this, and I frankly didn't go back and review this transcript from the original, trial. But why did the assistant state attorney volunteer to the judge that there had been this plea offer? Did the judge ask?
It's not in any record.
Or was the state attorney saying, Judge, I'm making a plea offer right now?
It's unclear.
It's unclear.
We just don't
I mean,
know.
sometimes, the judge says, hey, have you guys negotiated it all? They want to know.
Absolutely.
But there's no indication in what we have before us that that's what happened.
Correct. If there are any other questions? All right, we ask that you reverse. Thank you so much.
Thank you both very much. And in order to leave our virtual courtroom, you click this button on your screen that says leave, and then you will. Okay.